Wonderful interlocutors, full of good questions and creative answers, and this talk today reflects some of the discussions we've had in that class. There may be a certain affinity between the mode of operation of a historian engaged in what is often called microhistory and that of a lawyer engaged in impact litigation. Describing a current project, we each begin with the phrase, "I'm working on a case in which," but of course, the historian should then clarify to her lawyer colleagues that all of the principals in the case she's working on have been dead for nearly 200 years. Both the historian and the lawyer are involved in discovery in the literal and the legal sense, facing heaps of hard-to-parse documents, combing through them for leads, looking for a narrative thread, sometimes despairing about the prospects for wrangling an idiosyncratic set of facts into an effective argument. But we both hold out the hope that a new understanding of the case at hand, which generally implies a reframing of the issues that it raises, might somehow alter the way we see the world. Now, there's, of course, a stark difference. In the year 2017, a good lawyer may succeed in getting a mother and her children released from immigration detention and start them on their way toward asylum as refugees if the court will recognize, acknowledge, adjudicate such a status as refugee. By contrast, there's nothing I can do to change the outcome of a lawsuit that sought a finding of status as free people for several girls, daughters of 2 war refugees who were being held as slaves in Havana in 1617. But by tracing the path by which that case came before a Cuban court, I hope to discern some of the complexities of the adjudication of status in an Atlantic and Caribbean world that was transformed by the Haitian Revolution of the late 18th century. And I'll argue that determinations of status rested on a tangled relationship between the law of persons and the law of property, and on very deep uncertainties about how one polity would deal with undocumented refugees from another. The law and statutes of slaveholding societies rarely provided much guidance for answering the question, who is slave and who is free? The key marker, and you'll see the circularity of this, the key marker of slave status was the fact that one was held as a slave, and hence seen to be owned as property. One of my students recently came across this definition in the Mississippi Slave Code, and I think it highlights the problem of circularity. All persons lawfully held to service for life and the descendants of the females of them shall be deemed slaves. No statement, of course, of what it would mean to be lawfully held to service for life. But even that Mississippi definition shifted just slightly in an intervening clause that added such person, dealing with those who were brought into the state or who came into the state. And so it included under the category slaves, quote, such persons and the descendants of the females of them as may hereafter be lawfully brought into the state, being held to service by the laws of the state or territory from which they have been removed. So you'll see already where the wedge may open up. If we think now back to the Haitian Revolution eventuated in a declaration of freedom for nearly 500,000 people. That revolution in the French colony of Saint-Domingue in 1793-94, as you will recall, took place here, French colony of Saint-Domingue, right in the middle of the Caribbean, adjacent to the Gulf of Mexico, right in the heart of the plantation Americas. It thus had the potential, or sort of the potential, we'll see how much that was eventuated, to alter presumptions elsewhere concerning status for persons of African descent. Now, the surrounding jurisdictions, largely in the immediate vicinity, the colonial possessions, the slaveholding colonial possessions of various European empires, were by no means willing to respect the freedom that freedoms formally granted during the Haitian Revolution, either by the Revolutionary Civil Commissioners or later by the French National Convention itself, they were not prepared to accept that that would determine the status of individuals. But it was hard to avoid having it have the potential to shape that status. So after 1793-94, the ownership of persons as property was a legal impossibility in Saint-Domingue, eventually Haiti. Now, the rulers of adjacent polities refused that declaration. They sought to discredit and, if possible, defeat the regimes that defended it. But there was no denying that that as an act had created, in effect, hundreds of thousands of persons of African descent who were not, strictly speaking, held as slaves under the laws of the polity in which they now lived and from which they might come. And in the face of the efforts first of the British and then later of Napoleonic France to try to suppress the Haitian Revolution, thousands of those persons became refugees, and they reached the shores of Cuba, Jamaica, and the United States. So now the question, would their freedom prove portable as they entered new jurisdictions? And I should open a parenthesis here. For the law professors among you, it's not just a question of choice of law. It used to be whenever I would talk about this problem, someone would raise their hand and say, but, excuse me, Professor Copper, it's just a question of choice of law. Either way, whether one wants to assert that the person is a slave and owned by another person, one has to reach back to the property law of the jurisdiction from which they've come. Otherwise, there's no initial property claim. Or if one wants to assert free status, one will be adverting to a different piece of Saint-Domingue law, that is to say the portion that comes after 1793-94. I'll close that defensive parenthesis there. So we can look at this question. We could look at this question of shifting jurisdictions and disputed status. We could look at it in terms of aggregate numbers. I could, for example, demonstrate that some 3,226 refugees from Saint-Domingue, Haiti, nearly all of whom had lived as free persons for at least a decade, were categorized as slaves upon their arrival in New Orleans in 1809.